9-0, a decision that echoes nationwide. Imagine waking up to flashbangs, smoke, and shouting. Armed agents storm in, yank you from bed, and point rifles at your family, all because they got the wrong address. And when it's over, they tell you, "You can't sue us, we had discretion." That nightmare is exactly what happened to Katrina Martin and her family. But this time, the U.S. The Supreme Court unanimously stepped in, issuing a rare and powerful 9-0 decision that could change how government raids, home searches, and federal immunity claims work across the country. This isn't just a victory for one family in Georgia. It's a warning shot to every federal agency hiding behind discretion, and it could redefine what accountability means under the Constitution. Let's walk through the Martin case, the ruling, and what it means for your rights, especially if you're a gun owner or a law-abiding American who just wants to be left alone. Section 1. The heart of the case. At the center of this decision is Martin v. United States, a case that started when federal agents raided the wrong home again. No drugs, no warrant tied to the actual occupant, just a mistake. But when Martin tried to sue for damages, he ran into something many Americans don't even realize exists: a legal wall called sovereign immunity. Martin filed under the Federal Tort Claims Act to seek compensation for the wrongful raid. The government claimed immunity under the discretionary function exception, a clause meant to protect federal agencies acting within their legal discretion. Lower courts sided with the government, blocking Martin's ability to even bring the case to trial. The question before the Supreme Court was whether the discretionary function exception could be used to shield federal agents from accountability in this context. The court's answer? A unanimous no. The justices ruled that immunity could not be stretched to cover this kind of clear overreach, setting a new precedent on when the government can and cannot avoid civil liability. Section 2. What the court actually said. In a striking rebuke, the Supreme Court made clear that the discretionary function exception has limits. Government agents don't get blanket protection just because their actions were tied to enforcement or policy. If the action was illegal or outside proper boundaries, the government can be held accountable. The court emphasized that constitutional violations are not protected under discretionary immunity. It clarified that the FTCA allows citizens to sue for government misconduct when agents exceed legal boundaries. This ruling aligns with the court's broader efforts to rein in administrative overreach. It also suggests stronger protections for individuals who've been wrongfully raided, arrested, or harmed by federal action. This decision doesn't just help Martin. It opens the door for others to hold the government responsible in similar situations, including cases tied to illegal gun raids or red flag enforcement without probable cause. Section 3. Why gun owners should care. Although this ruling wasn't about firearms directly, the implications for gun owners are huge. Many legal challenges to red flag laws, NFA enforcement, or ATF actions rely on whether citizens can even sue the government for damages after a bad search or raid. The court just made that path clearer. If the ATF mistakenly raids your home based on a flawed database or tip, you may now have a better chance of getting justice. The decision weakens one of the government's strongest shields: the ability to say, "We had discretion." Gun-related enforcement is often framed as policy-driven, but this ruling makes clear that illegal searches are not protected. Future cases involving confiscation or warrantless entry now have new legal support from this ruling. This case gives firepower in a legal sense to challenges against agencies that previously operated with near-total immunity, especially when firearms or constitutional rights are involved. Section 4. How this ties to Caniglia versus Strom. This isn't the first time the Supreme Court has taken a unanimous stance on unlawful entry and overreach. In Caniglia versus Strom, 2021, the court addressed a situation where police entered a man's home without a warrant and took his firearms not because of a crime, but under a so-called community caretaking exception. The ruling was 9-0. The court rejected that reasoning outright. Caniglia had argued with his wife, and after a wellness check, officers seized his guns without a warrant. Lower courts upheld the seizure under the community caretaking doctrine, which was never meant to apply to homes. The Supreme Court reversed that logic, stating that such exceptions might apply to cars, not private residences. The court emphasized that the home enjoys the highest level of Fourth Amendment protection. Now, in Martin v. United States, the court is reinforcing the same point from a different angle. They are not only rejecting unlawful entry, but also removing the shield of immunity that federal agents often hide behind when they go too far. It's no longer enough to say, "We thought it was allowed." What's clear is that Caniglia set the foundation, and Martin builds on it. The government cannot violate your Fourth Amendment rights then expect to be immune just because they work for a federal agency. Section 5. Why SCOTUS keeps voting 9-0 for your rights. If you've been paying attention over the last few years, there's a clear trend forming, and it's one most Americans can agree with. The Supreme Court is issuing more 9-0 rulings in favor of individual rights and against unchecked government action, especially when it involves search, seizure, or surveillance. In Torres versus Madrid, 2021, the court ruled that a person is seized under the Fourth Amendment, even if they get away after being shot by police. Reinforcing that force, not just custody, can trigger constitutional protections. In Long versus California, 2021, the court ruled police cannot always pursue someone into their home without a warrant, even for minor offenses. In Carpenter versus United States, 2018, the court held that the government needs a warrant to access your cell phone location history. In Martin, we now see this continue. Unconstitutional actions, even by federal agents, are not protected by default. These are not just technical decisions. They represent a clear pushback against government overreach. Whether it's firearms, privacy, or unlawful searches, the court is telling lower courts the Constitution doesn't bend for convenience. The rights of the people are not optional, and immunity is not automatic. Section 6. The real danger of immunity gone wrong. When government agents believe they can act without consequence, the risk to everyday Americans skyrockets. That's what Martin v. the United States just exposed, a system where even blatantly unconstitutional actions could be shielded by outdated legal doctrines. The government tried to invoke the Federal Tort Claims Act's discretionary function exception, which allows officials to avoid lawsuits for certain policy-based decisions. But the court ruled that constitutional violations are not discretionary. You can't call something a policy choice when it breaks the Constitution. This ruling stops that loophole from swallowing the rule, a massive shift in how agents must now think before they act. It's about more than paperwork. When agents raid the wrong home, when guns are seized without cause, or families are traumatized, there must be consequences. This decision begins to rebalance the power dynamic between the people and those sworn to protect them. Section 7. Why this affects gun owners. Specifically, many gun owners live in fear of one simple knock, the kind that comes not with a warrant but with assumptions. Someone filed a complaint, someone claimed a red flag, and suddenly federal agents are at your door. Martin reinforces that those agents can't act like the Constitution doesn't exist. In Henderson versus United States, the court ruled that even convicted felons have certain rights when it comes to transferring lawfully owned firearms. In McDonald v. Chicago and Heller, the court confirmed that the Second Amendment applies to individuals, not just militias. Now, Martin adds a layer. Fourth Amendment protections must be respected during any enforcement of Second Amendment-related laws. For gun owners, this ruling could be the line that stops rogue raids or overreaching seizures. And it signals that federal immunity is no longer a blanket excuse for violating your rights under the guise of public safety. Section 8. Lower courts are now on notice. The Supreme Court's ruling in Martin versus United States doesn't just end with Martin himself. It sends a loud message down the judicial ladder, especially to district and circuit courts that have been casually siding with law enforcement under official immunity doctrines. For years, lower courts have dismissed lawsuits before facts could even be heard, simply because the government said, "We followed policy." But Martin now forces judges to ask the deeper question: did that policy violate the Constitution? This is similar to Bivens versus 6 unknown named agents, where the court allowed a man to sue federal narcotics agents for an illegal home invasion, setting a rare precedent that constitutional violations can lead to damages. When courts rubber stamp immunity, victims are silenced. But now they're being told to slow down and look closer, even if the defendant wears a badge or suit. If constitutional rights are violated, the courtroom door cannot be slammed shut. This creates a shift in courtroom culture, one where agents don't just get a pass because they meant well, and one where Americans finally get a chance to be heard. Section 9. The impact on red flag laws and gun raids. This is where things hit home, literally. Martin may not have been about guns, but its implications are massive for those worried about red flag laws, NFA enforcement, and home seizures based on tips. In Caniglia versus Strom, 2021, a man's guns were taken by police during a wellness check without a warrant. The court ruled it unconstitutional. In Langa versus California, SCOTUS said hot pursuit alone doesn't give police unlimited rights to enter a home without a warrant. Now Martin adds fuel to the fire. Federal agents don't get immunity just because they were doing their job when they hurt someone unlawfully. Imagine an ATF raid on the wrong address. or a red flag seizure based on a neighbor's complaint, not evidence. Under this new precedent, if your Fourth Amendment rights are violated, you may now have a path to sue. For gun owners, that's a game changer. It means your home isn't just your castle, it's now backed by stronger legal teeth. No one should lose their rights because of bureaucratic mistakes or vague policies. Section 10. Even the lone dissenter matters. Justice Clarence Thomas was the only one who disagreed with the court's decision, but that doesn't mean he supported government overreach. In fact, it's the opposite. Thomas argued that constitutional claims should be handled directly under the Constitution, not by using the Federal Tort Claims Act, which is more about administrative liability. This reflects a trend in recent cases like Egbert versus Boulay and Hernandez versus Mesa, where the court limited Bivens-style remedies but still expressed concern about agent accountability. So while he dissented, Thomas wants a stronger, more direct path for victims, one that doesn't rely on old statutes to find justice. In plain terms, even the justice who voted no agrees the system is broken. He just wants a better fix. And when even dissenters are demanding reform, that tells you everything you need to know. So the ruling wasn't just 8-1, it was a near consensus on the need for accountability, just with a debate on how best to get there. That's a powerful sign of momentum. The legal shift no one's noticing. This ruling didn't trend on the front page. It wasn't announced with sirens, but it's one of the most important legal shifts we've seen in years. The Supreme Court just told the federal government, your badge is not a license to ignore the Constitution. This isn't just about immunity, it's about justice. It's about a veteran whose house gets raided over a paperwork error, the family whose legal firearms are seized under a vague claim, the homeowner who wakes up to find strangers in body armor claiming it's just a precaution. For all of them and for all of us, this ruling says the rules have changed, and next time, those agents might think twice. If you care about your rights, stay alert, stay informed, and make sure your friends and family know what this ruling really means. The battle for freedom doesn't always come with noise. Sometimes it's one quiet decision that rewrites the rules. Subscribe for more updates like this and stay safe, stay aware, and never forget your rights are worth defending.